Hey, everybody. We are here for our Facebook Live. So I'm Elizabeth Matherne,
I'm
and
Maria Batres.
welcome. Thank you for joining us. So today we are going to talk about a lot of different things. We're going to touch on the new Georgia law related to ICE holds and all of that. We did a Facebook Live a while back on that topic. We had some audio issues. We've since gotten that under control, and we're excited to talk about that again. We will give you any other immigration law updates that we know or just political stuff that we know is going on, and also answer your questions live, along with frequently asked questions that we have here in the office. So we'll give people time to join, but please feel free to give us those likes, those hearts, share. Make sure you like and follow so that you'll get notified when we do these lives. And feel free to pose questions. You can send us questions in the comments or through private chat. We can see both of those here. If your situation is a little bit private, then you can do it through private chat, and we can manage that and get your question answered either privately or online, because your question may be able to help other people. So Maria will summarize or do the same intro in Spanish, because we want to keep everything bilingual as much as possible.
Bienvenidos a todos. Hoy en la noche vamos a estar contestando sus preguntas en inglés y en español, y también hablando de algunos temas de inmigración. Específicamente vamos a hablar un poco de la nueva ley en Georgia, porque hemos tenido muchas preguntas. Hablamos de este tema hace unas semanas, pero sé que tuvimos problemas con nuestro sonido, entonces queremos asegurar que todos pueden entender lo que está pasando con los cambios con la ley en Georgia y qué sugerimos para cuando empieza esa ley a estar en efecto. Okay.
Very good.
Por favor, pongan sus preguntas. Si es algo privado o hay detalles específicos, siempre nos puede mandar aquí a Stern un mensaje privado en el Facebook. Pero si tienen preguntas que quieren que contestemos, por favor, póngalas aquí. Y también, si están viendo esto como grabación, también pueden poner sus preguntas y vamos a estar chequeando para responder a sus preguntas en el futuro.
Thank you, Maria. All right. So one of the things that people may be hearing about is this new Georgia law. So what do you think people are hearing about in the news? Like how have you seen it written about?
So I do think there's a lot of fear and concern about this Georgia law, in part because there are laws in other states that are being passed that are also very strongly anti-immigrant. And in particular, some that are being challenged in the courts in Texas, most recently, I believe, in Oklahoma. There are some laws in some states that are actually making it illegal, making it a crime to be present in that state while undocumented, and what's referred to as an illegal alien, illegal immigrant. And that is being challenged right now, because basically they're saying that your status makes you a criminal in that sense. Some of the laws even indicate that state could remove you from the state. So of course, these are being challenged. And I do think that initially when this law was going through our state legislature, there were some ideas about putting that type of language in here. But the good news is that is not what we've seen with this particular law. It is actually amending a law, and it's more about reporting people who are believed to be undocumented to ICE and giving ICE the opportunity to create what's called a retainer or a hold and determine if they want to take that person into ICE custody.
And so this is a really narrow context where we'll see this law being practically, I guess, in effect, right? It's really just deals with mostly people who are in a jail, and whether or not the jail must let ICE know that someone's there, right?
Correct. That's who's mainly going to be affected. It will affect in terms of the decision to arrest or release on a ticket, for example.
Okay.
Um, for example, we have oftentimes people who might be stopped for driving without a license, and an officer had the authority to arrest for certain types of citations. And that was the wording. Really, what's happened is the law that was in place is now being amended. And the wording gave an officer the authority to arrest or the authority to check in with ICE if they felt someone was undocumented. Now it is a requirement that if a person can't demonstrate that they're legally documented in the US upon a stop, then they must be taken into custody so that that assessment can be made and they can verify that person's lawful status. So between at the arrest spot, if you are stopped by police, and once you are in jail, are the two places where we will see this in effect.
Yeah, and I mean, it's something we always try to mention in all of our in any opportunity we can, is that traffic offenses in Georgia are misdemeanors. And so, yes, the police have the authority to arrest you. And where they had discretion to make a decision otherwise, this might take away some of that discretion, right?
This absolutely does. The language again is that the municipality or the city, the government, the law enforcement officer has the authority to reach out and even uphold things like 287G that we know really well in Georgia is once you've been arrested that they contact ICE. Now the difference in the language is that they shall, and shall is the word that is used in legal terms when it says you must. You have to do this. And it actually creates penalties for either the municipalities, the law enforcement officers. We have yet to see how that's going to be carried out, but it actually creates a misdemeanor penalty for those who fail to abide by this status check law.
Which is really interesting because generally people who work for the government have sovereign immunity, right? Like you can't violate the law that you're, I guess, entrusted to see through, unless you're like operating outside of what is approved. So that's an interesting kind of development in, I guess, how we're seeing our laws going. That we are trying to hold law enforcement more accountable for excessive use of force and things like that. And the legislature in Georgia sort of used that trend here to hold law enforcement accountable for using discretion whether or not to report that someone may or may not have status in their facility. It's kind of perverse and it makes me kind of mad, but at the same time, it is what they're doing. Now, we've seen similar laws roll out before, similar controversial things happen before related to immigration enforcement, sort of being put in the hands of local law enforcement. And we've seen that usually lawsuits start, and that as part of those lawsuits, injunctions happen. And that's like a legal way of saying that a judge can sort of freeze the implementation of a law. And so I anticipate that that's what we're going to see. I anticipate we will see the day that this is supposed to roll out, or within a few weeks or months, that we'll see lawsuits being filed. You know, somebody's got to have standing to bring a lawsuit. So it's got to like kind of happen to somebody first and be in a good factual scenario where it's sort of unfair and demonstrates why this law is potentially like an overreach. And then a lawsuit can be brought to challenge the legitimacy of the law, and then a judge can put a freeze on the implementation of the law. But we can't count on that until we see it happen. So, Maria, what are some of the things that people can do to prepare, or like mentally prepare, or what can they do to sort of help themselves stay safe in a way from when this law starts.
And I was going to mention that that is probably the most common question that we get. What can I do to try and avoid being caught up in this situation? And first and foremost, if you are here on any legal status, carry copies of your documents with you, carry proof. If you have a green card, have that with you. If you have a work visa, a driver's license that you've gotten through the process that has the star in the side that shows that it's been verified with the ID. Any sort of receipt notices, perhaps, let's say your work card has expired, but you're under lawful status of TPS or something like that, carry at the very least a receipt notice, because that may help. If you're able to show that you're in lawful status upon, let's say you're in an accident and the police come to investigate and they're considering an arrest for any of the charges, excuse me, that may actually help this situation to where you might not be put in that situation. Or at the very least, have your family know where those documents are. So if that needs to be provided, you need to reach out to us as attorneys to help provide that so that we can provide that proof. But a question I get from a lot of clients, Elizabeth, is we have a number of clients who aren't documented. And so how will that affect them if they are not able to present that proof? What are the risks? Are they going to immediately be taken to ICE? What will happen there?
So you're right. This is something that people get scared of, right? Will they just be whisked away from the scene of the arrest directly in, well, some people worry directly into immigration custody or directly just deported. Mm-hmm. So, the answer is, always as a lawyer, it depends, right? But usually you have a right to fight the criminal charge, whatever it may be, even if it's, a DUI or a driver without a license. And so that's going to be the first step. If you have a criminal charge, you would go into criminal custody and you'd be able to fight that charge. You might get a bond in that case. If you pay the bond and you have an ICE hold, that means you'd be transferred into immigration custody. In immigration custody, you may be eligible for an immigration bond. And you would be able to ask an immigration judge for a bond. And if you got out on both of your bonds, you could fight both of your cases from outside of detention. Where things get a little bit tricky is if you've already been ordered removed before, you may be subject to what we call reinstatement. So if you got arrested on a criminal charge, you have an ICE hold, you move over into ICE custody, and you have a removal order, they can just use that old removal order and remove you. You wouldn't be entitled to see an immigration judge unless you had some sort of very high level fear of the government of your home country, right? And you could request for that to be reviewed. But things do not move very quickly as far as all those steps are concerned. So you wouldn't just be overnight moved from criminal custody to be removed, right? But if you do have a removal order and you want to get ahead on all of this, just in case you got caught driving without a license or something like that, it's really, really important if you have an old removal order and you're in the United States to have your case reviewed by an attorney. Because if we start working on reopening a removal order, sometimes we can reopen a removal order. Maybe something was done wrong in the original case. Maybe you have newly available relief or some sort of humanitarian situation that justifies reopening the case. And if you did that now, then you're not in the position of being detained and trying to do everything, as fast as possible to start the train that's already moving forward. So that's a consideration. And then the timing of paying one bond and moving into the next set of custody, that's also another consideration and a place where we can talk about things. So all that to say, it doesn't happen overnight, but it also is pretty complicated. And there are a lot of steps and a lot of things that need to happen and need to be coordinated. So And I usually have to walk people through that a lot. That's something that is really, really hard just for everybody to understand, even lawyers to understand how the intersection of a criminal arrest and an ICE hold works. Sometimes people will try to go pay the criminal bond, and the bond office will say, we can't take it, you have an ICE hold. Well, I mean, they can take it. They're in a like have a policy that they don't want to take the bond payment because they know the person's going to move into ICE custody, and that's just what people don't expect sometimes, and they don't want people being mad at them. So it is complicated. Um, and so I think we're going to see more of that if this law does go into effect, and we need to help people navigate all of that. So, long answer to a short question.
Absolutely. And it's important that if you are concerned about it, you're concerned maybe years ago you entered unlawfully and were detained, and you don't know what happened with that case. It's important that you reach out to us and see what your options are. And especially if you are arrested, before a bond is paid, before any plea is taken where you think you might be automatically released, it's going to be very important that you consult with an attorney. And if you are not, well, if you're an immigrant, whether it be documented or undocumented, it's important that you also consult with someone who understands the criminal consequences to your immigration status. Because you might plead to something because they tell you, well, you'll be released today, but that could be something, even if it's minor, that could end up affecting your ability to apply even for citizenship in a certain amount of time. If it could affect whether you maintain your TPS if you plead to 2 or 3 charges on one crime. So it's really important that you reach out to an attorney. Our firm is actually very focused on that intersection between criminal and immigration, and we can actually handle both sides of that case for you. So if that is your situation, please give us a call if you have any questions about how to be prepared for this.
Yeah. One thing you mentioned, Maria, made me think of something. If somebody's been stopped at the border and then released, and it's been a really long time since that happened, or even if it just happened recently, a lot of people assume that because they never went to court, that they got a removal order. That's not always the case. Our immigration court system has been so backlogged that there are people who have been literally waiting for court dates for over a decade. So it is possible that you have maybe an open immigration court case, you didn't get ordered deported, and maybe you're eligible for something. And it's a crazy set of facts, but we see it every day. You entered over 10 years ago, you were released, you never got a court date. You don't know that, but we find out you never got a court date. Then we look at the notice to appear and realize it was a defective notice to appear that can't stop your time. So maybe it was created right when you first entered. If we're able to get that thrown out and you've got 10 years of physical presence and a qualifying relative, you may be eligible for cancellation of removal and a work permit. So just because you think something happened in your case, don't just assume, right? You need to know for sure whether your immigration court case is still open, whether you're eligible for anything. That's one of like the biggest things I can tell people is don't just assume the worst. Sometimes there's real hope, like things can just come out of nowhere. And don't listen to people who are not immigration lawyers who are telling you about something that happened in their case or their cousin's case or whatever, telling you that you don't have any hope. I did a consultation with somebody a while back, and they were told that they had no status and were doing a consultation with us to see if they could gain status. The documents I reviewed showed me that they were actually a lawful permanent resident, and the person who was telling them that was an abusive relative who was trying to keep them, without knowing their status, so that they could kind of use that as a way to control them. And the person was eligible for naturalization, so they were only a step away from becoming a citizen. And that's just a really, really wonderful thing that we're able to do by looking at actual documentation or ordering a copy of your file or something like that. So
Yeah, that's a great example. I just want to touch, and it is rare that these things happen, but they do happen. I had a client come actually wanting to request a copy of her immigration file so that she could potentially apply for her green card because she'd been waiting for 21 years for her daughter to turn 21. And we were reviewing her documents and actually discovered that she had been granted a green card when she was 15 years old, but just had never received it. And so we were able to start looking into the process of saying she's been a green card holder. We could prove she'd maintained her residence here in the US. She had just never physically had that card. So these are the types of things, and something as little as you even having one document that maybe they gave you when you came in, your A number, anything that's going to help us look into your case so that we can see what options. And if you don't have an option like that, we're going to look and see what options you do have and fight for you to be able to find a way to stay here lawfully.
yeah. Yeah, it's really a fun job we have. It's kind of like solving puzzles, but also helping change people's lives. So we would be happy to do that review for you. And also, sometimes if the answer is there's nothing that can be done, that's also information that can inform decisions. And to know that someone's really turned over every leaf and double checked everything can give people peace of mind and can help you make decisions on what's next. And also be on the lookout will help educate you with things that you may be eligible for in the future should certain things happen. So we're happy to do that. What are some other frequently asked questions that you get, Maria?
I get a number of questions about from people who have children who have turned 21.
Yes.
And what is they're looking to see if there's now a path to get a green card through their child, and what types of information if they were calling us for a consult, would they need to have, or what types of questions they want to know, what information do I need to know to see if I can get my green card through my child?
Yeah, so this is something that the general public has a hard time understanding because it doesn't make sense, right? Your child that's over US citizen child that's over 21 can petition for you to certify the relationship that you're an immediate relative. But if you entered without inspection, you're not going to be able to convert that petition to a green card without some additional steps, which include going out of the country to come back in, to process back in. There is a waiver that exists, so you can file it ahead of time to know what the answer is before you go out of the country. But it doesn't use qualifying relatives as adult children. You can only do that waiver with spouses or parents. And so sometimes that's what we talk about. We look for, do you have a brother or a sister who's a United States citizen who could petition for your parent? Then your parent can come in as a lawful permanent resident, be a qualifying relative for your waiver. So when your child petitions for you, you can do the provisional waiver. Very complicated. So one of the main things that we look at is, how did you enter? And if you entered without inspection, what other relatives do you have? If you don't have any, then we move to, what other ways can we potentially adjust your status inside the United States, maybe through the relative or not. So, in light of Memorial Day, there is a thing called parole in place, right? This is an application that can parole or give an entry document to a parent, or it's an immediate relative, so it can be step parent. What else? Spouse. Is that it, Maria? For parole in place, I know it's biological parent and step parent, and then spouse.
Yeah.
I'm not sure if there's additional relatives. I feel like there's one more that I'm forgetting. But
Yeah.
If you're a immediate relative of a person who has been in the military, is currently in the military. If they have been in the military and they're still living, then they can be, as long as they were honorably discharged. And then also, it still is something that's valid and available even if the person is deceased. So that is something that many people don't know. So parole in place is an option potentially for people with an immediate relative, over 21, adult child, U.S. citizen, to petition for them. Also, VAWA can be an option. VAWA is Violence Against Women Act. If your relationship with your adult child constitutes, what is required for a VAWA, you could potentially apply and adjust without leaving the United States. And there's some other applications that don't relate to having that qualifying relative, like, for example, a U visa or things like that. So if you entered without inspection, we're going to start going down that decision tree of other options. If you did enter with inspection, completely different story, much more easy process. So you can file your application for your green card right here in the United States, not have to leave, get your work permit while it's pending, all of that. Very straightforward, generally. Now, what counts as, like, sorry, I think my audio cuts out when I get those alerts. What constitutes like an entry with inspection, Maria? Because that's something that I think is always kind of hard.
Absolutely. So there are certain elements. If you went through a actual border checkpoint and were passed through, you were admitted into the United States. Sometimes even we can demonstrate that that admission was by fraud. Certainly, there's a waiver that would be needed, and that could hinder your application in the future. But if that happened to be the situation, but you could actually say, I crossed through the border, or I passed with a border crossing card, or I passed with my own visa. Then all of those are considered admissions. And even in some cases, we can demonstrate that what we call a wave through can be a lawful admission. I just had a case today or this week that the client was in a car, asleep as a child, when the car went through the border, and the officer basically didn't ask any questions, waved through at an actual checkpoint. And so that can be argued that that was a lawful entry. There's case law that says that that can constitute a lawful entry. And so even if it was so long ago, you were a child, you're not sure exactly how you came in, giving us those details when you call are going to help us ask the follow-up questions to determine if you have that lawful entry. Also, recently, things like advanced parole, if you're on DACA and you have gotten permission to travel and returned on advanced parole, that's an admission. If you have TPS, especially recently traveled on TPS, there's a new travel authorization, which has now finally been confirmed to be a lawful admission for the purpose of adjustment of status. So if you have DACA or TPS and know you came in undocumented or across the border, come and talk to us, because if you have a reason to travel and are approved for that travel authorization, you might be able to follow that path to adjustment of status.
Yeah, and there's one other, right? Parole. If you're paroled in, and now there's different types of parole, and so we'd need to see like your actual document to see how you were paroled and to see if that qualifies. And so if you are interested in trying to adjust status through an adult U.S. citizen child, an over 21 U.S. citizen child, these are the kind of things we're going to ask you about and kind of what you can think about and look into. And same with people who are married to a U.S. citizen or a lawful permanent resident. We need to know, one of the very first things we're going to ask is, how did you enter? And U.S. immigration law is split that way. It really has two different sets of sort of rules, laws, pathways, depending on how you entered the United States. So yeah, that's something we get a lot.
So in terms of talking about adjustment and possibilities of legalizing status, obviously we come across a lot of our clients who have criminal history. what type of information should they have when they call us for a consult? Should they be concerned with something as minimal as a DUI or anything like that if they're planning to apply for some of these? Is that something that we can help them look into and determine whether it would affect them?
Yeah, I think it is hard to know whether something you're convicted of or charged with is going to affect your ability to get your status or keep your status. There's not like a super easy bright line rule. A lot of people think, oh, if it's not a felony, I'm fine. Or if it's a misdemeanor, or if it's just a ticket or things like that, I'm fine. It's not going to affect me. I'll be able to get my green card, or I'm not in jeopardy of losing my green card. And that's just not true. So it is really, really important that if you have anything like that going on and you do want to have your case evaluated, any paperwork that you can bring us related to the charge or the way the case was resolved really helps us like make a very clear analysis. When you tell us what happened, that is like kind of the facts behind the situation, but the actual documentation, what the judge signed off on to close the case, or how the prosecutor or the police officer actually wrote the charging document, what they charged you with under what statute. Believe it or not, there's kind of like different statutes that you could use to charge, that a prosecutor could use to charge someone based on the same facts. And some might cause you immigration consequences and others might not. So we really need to know under what statute was your case, dealing with, and how did it close? You might be told that a case was dismissed, but it might still be a conviction under immigration consequences. So, that's all to say, the more documentation you can give us, the better. Now, if you don't have it and you don't know how to get it, that's okay. We can help you figure that out so that you can get a very clear analysis. And that's also kind of like a place where I would caution people, right? You can go to an attorney that practices only immigration or only criminal law, and they can use their best guess to tell you, oh yeah, you're eligible for this, or you're not, and not look at your documents, just listen to what you tell them and say, well, that sounds like you were charged with probably shoplifting, and you're telling me that it was dismissed. So, okay, let's go forward. Let's file the green card application, or let's go ahead and have you take this other charge. That's not the sign of, in my opinion, a really good lawyer, right? Really good lawyers operate in facts. We want to operate with like exactly what it says in the statute, exactly what it says on your documents, not what your memory or your non-lawyer analysis is of what happened. It's not to discount that what you have experienced and remember is not important and valid. It's just that you want an attorney that does that extra level of checking and understanding the facts of your case so that they can navigate exactly the way your case should be navigated, right? I mean, yeah. I think that's pretty clear for most people.
And I want to touch on something that you mentioned where, you're told that something is dismissed or it's been erased. We get that a lot. We ask, have you ever been arrested? And the answer is no. But then as we ask follow-ups, they say, well, it was dismissed or I paid it, so it's done. So keep that in mind, that unfortunately for immigration, things that maybe, for example, in Georgia, we have First Offender Act that can cancel out a conviction after the fact or seal it so it's not out in the public. That still counts as a conviction for immigration. It still has to be disclosed in that element. And that's something that we, having the experience in both immigration and criminal, can see where those might affect you. Make sure that you have the copies you need before a case is sealed so that you are able to show everything in the future. But please don't think that because something was dismissed or paid that it is gone off your record. And the more that we can know, the more we can help you and make sure we are ready to meet any hurdle through your process, it doesn't necessarily mean it's going to disqualify you.
Right.
So the more that you can share with us, the more it will help us make sure that you can go through the process smoothly and successfully.
That's a really good point. Yeah, it doesn't mean it's the end of the world. There are waivers, there are all sorts of things that we can do that we know how to navigate. And first offender is something that we hear a lot about, and so many people think that they're not convicted of a crime. When under state law, you pretty much are not convicted. You can truthfully answer once you have something expunged under first offender that you were not convicted of the crime. However, for immigration purposes, that is absolutely not the case. Another thing that you see is pretrial diversion, right? Some people get pretrial diversion or pay a ticket or a fine and they think that it's gone. And it's reasonable for people to think that. There are legal systems in other countries work different ways, and people are told directly some of these things by attorneys who they trust. So we totally understand why you might have a misunderstanding if you're finding yourself in that position. However, the consequences of that misunderstanding can be really harsh. So that's why we want to help you get ahead on that if you are charged with a crime. Or you get a ticket, it can be for a crime. For example, possession of marijuana or shoplifting can be charged on a ticket. And if you just pay a fine or you bond out and they apply the bond, like you didn't even come out with any other money or stand in front of a judge and say you're guilty, you will have a conviction on your record and you will have been found guilty. So that could make you have some pretty serious immigration consequences. That those are things that we talk about and seem really, really straightforward, but we also understand how it's very confusing.
Absolutely. So, Elizabeth, you mentioned it's Memorial Day coming up. And of course, we want everyone to be safe and not drink and drive, don't get in any bad situations. But we also know that our law enforcement is out there keeping our roads safe, being extra vigilant because a lot of people are traveling and out on the roads. What would you recommend to anyone who is encountered by the police for a DUI, for any sort of driving without a license? What advice would you give them in terms of when to reach out to us and what to do if they do find themselves in a situation where they're arrested this weekend?
Yeah, so the best thing you can do if you're arrested, I mean, obviously, I want to caution everybody, stay off the roads if you can, right? You got to go to work and you've got to pick your kids up or go to the emergency room, God forbid, things like that. But if you can stay off the road during these holiday weekends or holidays, it really is wise because law enforcement's out there and looking for anybody that they can interact with. And sometimes you'll see checkpoints and things like that to try to catch DUIs. Some general advice for if you have interaction with law enforcement is that you do have the right to remain silent. You don't have to answer questions that will implicate your guilt. So you don't have to answer how many beers have you had, things like that. Now you do have to provide your identification if you're asked for it. You do have to do what you're asked to do, if that's to get out of the car, to put your hands up, things like that. But you do not need to answer questions about whether you've done a thing that may be a crime. So I think it's hard in the moment because generally people really do want to do what's asked of them, and they think that if I'm truthful, the police can maybe help me. That's not necessarily untrue, but it isn't what a criminal defense attorney like myself would recommend, right? So you want to be respectful, you want to follow instructions, but you don't want to incriminate yourself or give any extra details that could be used against you later in the case. What do you think, Maria? Would you add anything else?
No, I would agree. And then I would just say if you are if you are taken into custody and you're arrested and you're given a bond, specifically if you are undocumented, have someone reach out to our office prior to paying a bond, especially if you're not sure of your immigration history. Even though the new law that we started out talking about is officially fully into effect in December of this year, we've already seen that agencies are leaning more towards the actual reporting to ICE, and they can put a nice hold on you. And of course, a DUI can be considered a dangerous crime, right? It can be a danger to the community. So it is very possible that you could be referred to ICE. And prior to paying any bond, prior to being released or perhaps transferred to detention, it's always important to reach out to us. We can help you with the DUI defense while also assessing and preparing for if and when you do get put into immigration proceedings. So, as Elizabeth said, be respectful, answer only what you need to, but also if you do, for example, refuse to do the tests, et cetera, chances are you're going to be arrested simply so they can complete their investigation, or in an abundance of caution to the community, right? But that doesn't mean the case is over. Reach out to us, because it's only the beginning, and that's where we start working for you to help you through the process.
Yeah, it's good advice. Okay, so let's see, what else can we I'm trying to think what else would be good in these last few minutes that we have to mention to people. I know that, yeah, go ahead. Did you have a thought?
No, go ahead. Oh, I do want to say, if you have TPS, please keep in mind that there are re-registration dates. For many of you, you've had TPS for years and you've just been told it's automatically extended. You don't have to refile anything. If you're not sure if you need to reapply, the information is on the USCIS website, but reach out to us. And specifically, if since your last renewal, you have had any arrests, tickets in Georgia, misdemeanors, certainly reach out to us before reapplying so that we can assess your eligibility. But what you don't want to do is miss that deadline, because then you may lose your TPS. Same thing with DACA. If your DACA is coming up on 8 months, 6 months even, there's not a specific requirement of time for when you can renew your DACA. We obviously may see changes with the next administration. So extend that DACA. If you didn't just renew it recently, you can reach out to us, or you can do that on your own. And then, like we mentioned before, if you haven't traveled on either of those and you have family that you've been wanting to see and you have a reason, this would be the time to try and get that travel in, so that even if maybe right now you don't have that option, you don't have that family member who could qualify you, it's something that you would have in the future.
Yeah, it's really, really important with immigration law, because it does shift and change in ways that we don't necessarily know. That if you are eligible for anything, you take advantage of it. I know that when TPS had advanced parole, it's had the opportunity to do advanced parole for a really long time, and there were a lot of people that made sure they did it and were able to adjust, 20 years later, because they did travel on advanced parole. It's a little bit more touch and go now with TPS advanced parole, but for DACA holders, we don't know if DACA is going to stick around. It's likely that it won't. So now is the opportunity to utilize the ability to do advanced parole under DACA, like Maria said. So important. And, DACA, I guess one of the frequently asked questions that I see is, like, for a DACA holder that gets arrested and they need to renew their DACA, what do they do? It's always kind of tricky, because people are afraid that when they send in that renewal, that the USCIS is going to get flagged that they have a new arrest. Have you seen those, Maria? Do you have any tips for people?
So, absolutely. I think reach out to us again. It's important that you determine or have some insight into what you may plead to, right? And working with an attorney, if you have a crime, like a DUI, for example, that could be considered a serious misdemeanor. So, and it may be looking at your history of the past. Is this the first time you've ever had a ticket or an arrest? Is it a domestic violence charge or any sort of battery charge? Those are things that could affect. So I would say, first and foremost, before resolving that case, come to us. And if you have had that situation, that's something we can also assess as well, if that you were properly advised when you took that plea, that there is obviously we can't just change something because it's affecting your immigration. But there are some people who maybe got improper advice and took a plea believing and feeling that it was not going to affect that. And constitutionally, they were not properly given their rights. And that's something we can look at. But if you do get arrested, if you have any case, it is important to reach out, because sometimes we can work something down. We can get something dismissed with a pretrial diversion, something like that, because you don't want to lose that DACA. I know you all know how precious it is and how wonderful it has been. So, certainly reach out to us if that's your situation.
And another thing that you don't want to happen is to not file your renewal and you go over 1 year past the expiration, because then that would require a new filing. And new filings are not being processed at this time. So you would potentially lose DACA forever just because you didn't file the paperwork. And I know it's scary when you have a criminal charge and you don't know how it's going to be resolved, to put that renewal out there. But if you also at the same time have a criminal attorney that understands the immigration consequences, and you can have that same person working on both things, you can potentially keep the DACA intact. You have a much better chance, and it's rather than just not filing the renewal at all and kind of burying your head in the sand and hoping that you'll get the criminal case resolved and then you'll file the DACA renewal. I've just seen that really not work out for people. Now, also sometimes you're charged with a very serious offense, and it may look unlikely that you're going to be able to keep your DACA. Maybe the criminal case won't be resolved in your favor. But at the same time, things happen. Like we can see, I do believe miracles happen every day. And I believe that we don't know how cases are going to get resolved, and that every day with every case that we have, we try everything we possibly can and we see doors open, and we do the very, very best we can with every case we have. And I am excited. I have a case that it's still in progress, so I don't want to give you the full update tonight. But like Maria was talking about how sometimes we discover that a plea to a very serious charge cannot stand because it's unconstitutional, right? It's constitutionally defective, and that we do have tools to try to reopen cases and change the result. It's not an easy task, but and it takes a while, and how that fits in with the immigration case and fighting for your residency or keeping the residency at the same time is a really multifaceted legal situation. And we've got a client that we've made some really, really big strides on. It's been kind of miracle after miracle. And we're looking at being able to resolve the original charge in an immigration safe way. So where somebody at a matter of months ago was looking at not only losing their residency, having a very long prison sentence, but also looking at getting deported at the end of the prison sentence and never being allowed to come back, is now looking at the very real possibility of being eligible for parole very quickly, having their removal order reopened, and being able to potentially keep their green card and be released from prison, not have an extremely serious conviction on their record, and be able to maintain their residency and potentially be eligible for citizenship, with a lot of hard work and blood, sweat, and tears. but it's a complete 360 for a person, and how their life trajectory was looking to how it potentially is looking now. So once everything is like in stone, and all of those documents are stamped and filed with the clerk's office, I will update you guys on that case. But it's really, really looking good. So I'm knocking on wood. I'm sending up my prayers, and I'm hoping that everything stays the way it is right now. But I'm going to keep y'all posted, and we'll have more, case victories and wonderful stories. We have amazing clients that inspire us every day. We love the work we do. We love being on here answering your questions and talking about the work we do. So please make sure, if you see this Facebook Live after the fact, and you're not able to ask questions live, feel free to post them on the comments or in chat so we can get in touch with you. Like, follow, give us some thumbs up, and make sure that you sign up for the little alert so that you'll know when we do our Facebook Lives, and you can watch with us and ask questions live.
Yep.
So we should see you guys again next week at 7 o'clock on Wednesday.
All right. Thanks so much. Share this if it's been helpful to you. Share it with your friends.
All right. Have a great night, everybody. Take care.
Bye.
Bye-bye.